Go ahead, Aidan. What do you got?
No.
Any questions, guys?
Reaction to what you just went through there, guys.
Wait for the court to decide. We think it's a very strong application. We think there is a strong motion to dismiss also waiting in the wings if this one doesn't go our way. So we're pleased with today. We have a judge who's obviously very informed, very prepared, and we're confident in what the outcome will be, whether it's on this motion, the next one, or the final result.
It seemed like the judge was leaning toward just, keeping Cosgrove on the case, but having someone else handle the Lindsay situation, I guess. Is that something you would be open to? It sounds like maybe not.
We think there's a conflict that requires removal, but the judge wears the robe and decides. So what he decides will be.
Did you get a sense of where he was leaning? It seemed like he was taking a, sort of active approach, poking holes, not just in your argument, but in the Commonwealth's as well.
He was a hot bench. That happens from time to time. That's what lawyers deal with, and you deal with it. So I don't read into it one way or the other.
You seem to give some credit to a strong motion to dismiss, which of course we now at least have a date for. Thoughts on that?
It is a strong motion to dismiss, but first things first. We have to see if there's a prosecutor to even defend the motion to dismiss. If there is, then we'll come right back here at the end of March and argue why all the indictments should be dismissed. Absolutely. I think he's right.
It used to be just the appearance of impropriety was enough to have somebody step aside. Would you step aside if you were in his role?
If I were sued by a witness in a case I was prosecuting back when I was a prosecutor, I personally would take the exit ramp and get out of there, yes.
So why is he fighting so hard to stay on this case?
That's for him to answer. I don't want to speculate. We have great personal respect for Mr. Cosgrove. It has nothing to do with the position that he's in because of a witness's accusations towards him, but I would not even pretend to try to read his mind as to why he's doing what he's doing. That's a question only he can answer.
Do you think they would struggle to find someone else to join this case? Obviously, they couldn't find someone to prosecute the 24 case that they null-prossed.
Would you do it?
I'm not a lawyer.
If you were a lawyer, that's their problem. That's a them problem, not an us problem.
How do you like his response, Cosgrove's response, when comparing the case you conflicted out of with these cases? How is that different?
To us, it's a distinction without a difference. I think we made that point very clear in the written submissions and the oral argument today. He disagrees, as is his right. That's how litigation works. But for us, if you're being sued by a witness, you shouldn't be examining the witness and summing up on their credibility when that witness has testimony that could impeach other important witnesses. It's just, we don't think it's appropriate, but we don't decide either.
What's the case in Middlesex we keep hearing about?
I'm not sure.
There's probably one there too. Anybody else?
He did mention that, you're close to, it seems, settling that civil case that you filed, Aidan. How does that impact what's going on here with the conflict and all that?
I don't think it impacts it at all because it's not almost settled with him, and he's the issue here.
The court seemed to go into some great detail about the timing of certain events, and Cosgrove came to this late. After all, the fact is Cosgrove is the one being sued by a potential a witness, perhaps to be cross-examined or directly examined by him. What do you think about the court's distinction they were drawing there and the timing of all these things?
I don't know that the timing per se matters. Our issue is that for one reason or another, the prosecutor, the only prosecutor on the case, we believe has a personal interest in discrediting witnesses or a witness who has sued him and defending the credibility of witnesses whose credibility will be attacked by the civil plaintiff. Whether that happened now, before, his personal interest is to restore his integrity, his reputation. Anyone who is sued and accused of things has an interest in discrediting that. How do you do that when acting as a prosecutor? We just don't think that that is appropriate. There's an appearance of a conflict, and we do think it does matter that you cannot look at this in a vacuum. This case is filled with conflicts that long precede Mr. Cosgrove. The state police are involved in the conflict who should have recused themselves. The DA is not involved in this. The former special prosecutor, Ken Mello, was booted off the case for having conflicts with Ms. Gaetani. by the way. Mr. Cosgrove already had another conflict with Ms. Gaetani. I don't think you can look at this in a vacuum. The public confidence matters in a criminal proceeding, and it's flagging right now here.
And she's not a potential witness. According to Brian Tully's 911 call on Christmas Eve 2023, he called her a witness, not a potential witness, 4 times. So she was a witness until she wasn't.
And in his affidavit, he swore in his search warrant affidavit that she was a potential witness. Not even a potential witness, she was a witness. So, you know, there's no question she's involved in the case. It creates a appearance of impropriety. It creates an appearance of a conflict. We think that's all we need. So, and while we're here, guys, Judge Bellizo said something very interesting that I want every member of the media to think about, okay? He said that he thought this case should be resolved by a jury, you know, as the conscience of the community, if you will, to decide whether this is a First Amendment issue or not. Now, we think that a journalist, and there's a few journalists here, shouldn't have to go through paying lawyers, risking their future in front of a jury. We think in this Commonwealth that judges should be a bulwark against this stuff. Judges should decide as a preliminary matter, should a journalist, should anyone speaking out, especially against the government, have to go through this to get to a jury trial, to spend hundreds of thousands of dollars, to spend all of this court time, years of court time, to decide if something is protected by the First Amendment. Judges in this state need to step up and stop these kinds of prosecutions. This is the most self-interested prosecution, and it's clearly viewpoint discrimination. They didn't like what Aidan was saying, so they went after him. Who else have they ever gone after in this regard? No one ever. So they're turning this statute on its head to go to suppress Aidan's viewpoint. That is wrong. We've always contended the judges in the state should take care of that. He should not have to risk the whims of a jury, the vagaries of the jury system to vindicate the First Amendment.
One thing the court did seem confident in is getting this to trial as quickly as possible. What do you take from that, Aidan?
If we have to do it, we have to do it. I'm not afraid of a trial. The facts would come out, but we believe it shouldn't come to that because, like my attorney said here, time, money, still being on bail, these are things that no one should have to live with for doing acts of journalism.
Shouldn't have gotten this far is our position, guys. And every judge wants to move the docket, though. Every judge wants to move things along. We're doing our best we can. We're not going to go to trial on this thing until every bit of discovery is in our possession. And there's still a ways to go. That's another battle we have to fight coming up. We're most interested, however, in the motion to dismiss. We want to get that going. Josie, anything?
No, actually.
All right. Anybody? Everybody taken care of? We don't want to